So let's turn one to Jerry. I think with the trends that you mentioned arising from the class action report, it would be interesting to hear from you about how employers can possibly lower their litigation risk through counseling or other type activities pre-litigation or outside of litigation.
Well, I'm a big believer in the notion that none of these cases ever come as a surprise. There are warning signs, and if the radar is out, an employer knows when it's coming in terms of employee grievances. And so I think any efforts made internally at a company to resolve issues through the HR department or to do or create notions of workplace due process so a worker thinks they're being treated fairly. They don't have to vote with their feet and go visit the EEOC or the Department of Labor. Please file a lawsuit on my behalf, or visit a plaintiff's lawyer to do so. I think one of the key defining moments of 2017, perhaps 2018, will be what the U.S. Supreme Court decides to do with the current dispute over the use of workplace arbitration programs. I do believe that use of an arbitration program, if carefully crafted and appropriately implemented, can significantly reduce exposure to class action risks. That case or set of cases will be argued sometime in the fall of 2017. More likely than not, President Trump's new nominee for the bench, hopefully or maybe, gets appointed to the Supreme Court and takes his seat, and so there'll be a full complement of 9 judges. I think that will be the decision next year. It's called the EPIC case, and it will be an EPIC case. Will determine the ability of employers to utilize those sorts of arrangements and agreements and processes to control, manage, and reduce the cost or exposure of these class actions. So I would follow those developments closely and determine what to do based and take your cue on what comes out of Washington, D.C.